Okay, I'll go ahead and make some announcements. So greetings, everyone. My name is Rachel Hasna, and I am with University of New Mexico's Division for Community Behavioral Health. Thank you for joining us and welcome. A couple of housekeeping announcements. So in terms of the evaluation, we will be posting that in the chat. If you toggle the menu at the bottom of your screen, there's a chat icon. You'll click that. That's where you will find the link. Copy and paste it. Or click on it and then fill out the evaluation. A certificate of completion is automatically generated. Please save a copy. It is your responsibility to save a copy. If you're on your smartphone, you'll want to do a screenshot. If you're on your computer, just save a copy of the document or a PDF. If you're joining us by phone, you can always email me and I will get you that link. We will have the recording link as well as the PowerPoint sent out to folks by the end of the week. And I also just wanted to give everybody a heads up for the next following 2 sessions. I will be working. Julie will be hosting the series. And so if you guys have urgent inquiries about your evaluation or if something didn't go right with saving a copy of your certificate, there's just going to be a couple of weeks delay, but we'll make sure to keep the evaluations open for longer. So please don't panic and just be patient until we come back, I believe January 4th, Monday the 4th. So thanks so much.
Thanks, Rachel. Welcome everyone to the University of New Mexico Law and Mental Health Didactics Series. This series is hosted by the University of New Mexico Department of Psychiatry and Behavioral Sciences and the New Mexico Behavioral Health Services Division. We're so glad to have you all here joining us today. My name is Julie Brovko. I'm an assistant clinical professor in the Department of Psychiatry and Behavioral Sciences. Now, first, I want to announce that we are accepting applications for our forensic postdoctoral fellowship. We have 2 spots available for the 2021-2022 year. Our brochure is ready to go. Applications are due on January 14th. And I'm so excited to let you know that we were just approved for the 5-year waiver. Email me or James Fairfax Colombo if you'd like a copy of the brochure. Next, I want to remind you to please join us next week. At that time, Dr. Robert Cochran will be presenting Providing Forensic Supervision. Now for our talk today, please ask questions in the Q&A anytime you feel comfortable, but just know we're not going to get to them until the end. Also, I want to let you know we really do try our best to get to as many of your questions as possible, but please forgive us if we're not able to get to yours today. Next, for those of you who want CEUs but are on a tight schedule, just know you do need to stay for that full hour, but you don't have to stay longer than that. So I'll try to let you know when that hour has passed, but we will likely be staying on a little bit longer to try and address more of your questions. So now it's time for what we've all been waiting for. I'd like to introduce to you our speaker for today, Dr. David Mrad. Dr. Mrad received his doctorate in clinical psychology from the University of Missouri, St. Louis. He worked for 25 years in the Federal Bureau of Prisons, where his work included treatment of offenders with severe and persistent mental disorders, forensic evaluations of defendants for federal courts, and for almost 20 years, the supervision of predoctoral interns. He taught at Drury and Missouri State Universities and was a professor of psychology and director of clinical training at Forrest Institute, where he also had a part-time private practice in criminal forensic psychology. Dr. Mrad's interests include forensic assessments of competency to stand trial, criminal responsibility, and risk assessments. He's a member of the American Psychological Association and the American Psychology Law Society. He's been board certified in forensic psychology for 25 years by the American Board of Professional Psychology. He's co-author of Examinations of Criminal Responsibility, Foundations in Mental Health Case Law, and author or co-author of several book chapters and articles in forensic psychology. Dr. Mrad, on behalf of the University of New Mexico, the Department of Psychiatry and Behavioral Sciences, and New Mexico's Behavioral Health Services Division, I'd like to welcome you and thank you for presenting today. We're so grateful for your time and expertise, and I'm now going to turn it over to you.
Well, thank you, Julie, and I appreciate being given this opportunity. I'm going to go through, I'll go through the PowerPoints, and you've already covered the brief bio, so I don't need to say much more about that. I will say I've been participating as an attendee in this series of presentations since probably early May, and after watching many of them and seeing the lineup of presenters who you've had in this series, I'm really honored and quite a bit humbled to be invited to present in this series. I feel a little bit like Archie Moonlight Graham being given an opportunity to play on the Field of Dreams. So hopefully I won't strike out, and we can have a hit here. So, okay. I have no financial relationship to this program, and these views that I'll be presenting are entirely mine and don't necessarily represent those of University of New Mexico. And let me add another disclaimer, because I have seen quite a few of these presentations, and I just want to let you know from the outset, this is not going to be a research-focused presentation. It's going to be one, the purpose really is going to be to help think about mental state at the time of an offense evaluations, how to think about them, how to organize them, how to conduct them. And so there's going to be a real clinical focus. And toward that end, I'll be using a lot of examples from my own experience. This is probably going to be, of less interest or value to forensic psychologists who have a great deal of experience. But for those who are newer in the work, I think it may be of more value. So the learning objectives really are, I'm going to be talking about a model for thinking about mental state at the time. And I keep saying that I will probably revert to just saying MSO evaluations, that stand for mental state at the time of the offense, just for brevity. But I would like for participants to understand the importance of viewing a defendant's behavior over a time continuum, and that'll be part of the model, and to be able to understand the necessity for a variety of sources and be able to list what many of those sources would be to do such an evaluation, and then to recognize how important it would be and how useful it would be to be able to integrate those different sources of information from what ultimately will be 6 different domains in forming an opinion that I think will be much more robust and defensible. One other thing I'd want to say is that this presentation I developed over a long time. I mean, I've been giving some form of this presentation for probably 25 years. And it started as really a presentation about the history of the insanity defense. And over time, it expanded and contained also information about how to do evaluations, what information to include. But that was like the lesser portion of the presentation. For the purposes of this presentation, though, I think that that's what would be more useful for most participants. And so I will be kind of reversing that. I still am going to spend a little bit of time talking about the insanity defense and the history of that, because I think it helps understand the concept or helps evaluate or understand the concept a little bit better, knowing its history. But I'll be focusing more than I usually do on the model and on thinking about those evaluations. That will also be sort of a question for time fit, since this was once a 2-hour presentation and is now going to be a 1-hour presentation. And I've tried to, arrange things so that it'll fit. So we'll see how that works. So I want to start with the basic concept that we're considering here. And it's the idea that a defendant, a person, should be blamed and punished, not just for what they do, but for what they are thinking and what they are intending. And that's a fairly long-standing and a pretty intuitive kind of idea. In fact, so much so that at the turn of the last century, Supreme Court Justice and Civil War veteran Oliver Wendell Holmes described that concept as even a dog knows the difference between being kicked and being stumbled over. And I think that captures how intuitive this concept is. So we're going to be talking about, I'm going to be talking about mental state and the way it relates to a defendant's blameworthiness at the time of an offense. And so I'll be talking about concepts such as insanity and intent. I'm not going to be talking about other issues that relate to mental state at a different time, like, for instance, at time of adjudication, competency to stand trial or enter a plea or represent oneself is not something I'll be discussing, though there will be some overlap in terms of some of the principles will apply. Okay, so the concept, mental state at the time of an offense. It really refers to a variety of legal questions. For instance, insanity or criminal responsibility, mens rea or intent to commit the offense, and also in some jurisdictions, sentencing considerations, because a defendant's mental state at the time may be taken into consideration, even if they are sane and intended to commit the crime and are convicted, it may be taken into consideration in their sentencing. What's common in all of these evaluations is that they're all retroactive. These are all retrospective. These are all not retroactive. They're all retrospective. These are all evaluations of some previous mental state, some previous time. And of these, insanity is certainly the most common one, the one that's most commonly requested and most commonly evaluated. So I'm going to say a little bit about the history, and I'll probably go through this fairly quickly. The history of the insanity defense. Many of you probably know that in most jurisdictions in the United States, our laws are based on English common law, and in English common law, the earliest codification of insanity was in the canon law of Bracton, and Bracton also established that there were at least two components to every crime. There was actus reus, or some voluntary act that had to have been committed, and there was mens rea, or guilty mind. So there had to be an act, the person had to have committed the crime, and they had to have had some kind of guilty mind or intent to do that particular crime. And Bracton said that an insane person was somebody who was lacking who was lacking mind and reason and didn't know what they were doing any more than a brute. And a brute was like, a farm animal, the domestic animal, ox or a horse. So that was a pretty high standard. I mean, to reach that standard, a person had to be severely lacking understanding and reason in order to kind of be like, a brute animal. So in the 1300s, English kings for the first time started pardoning murderers because they were suffering from madness. And then in 1505, there was the first jury acquittal on the basis of insanity. And with apologies to any attorneys who might be listening, I like to think of there as being kind of a hierarchy of defenses, at least a hierarchy of desirability of defenses, with the best one, the most desirable defense being the Sadi defense or actus reus defense, which is the acronym for some other dude did it. So obviously, if you can show that you weren't the person who committed the crime, that's the best defense. But oftentimes that's not really available. A bank robber is caught coming out of the bank red-handed, and maybe sometimes literally red-handed because die packs explode as he's leaving the bank. It's hard to say that some other dude did it in those circumstances. So then the next level, the next best defense is, well, yeah, I did it, but I didn't mean to do it. And that's a mens rea defense. I didn't really have the necessary intent. Again, that's frequently not really an available defense. Somebody goes into a bank, they have their face covered, they're carrying a gun, they have a note that says, give me all the money and don't hit the alarm. It's very difficult to explain that their intention was something other than robbing a bank. So then finally, if somebody can't use a Sadi defense or a mens rea defense, then they may rely on an affirmative defense that, yes, I did it, I meant to do it, but I should be excused from responsibility. And the affirmative defenses include, for instance, duress and necessity and self-defense, and the one that we're interested in, which is insanity. So there were attempts to explain what insanity would be. And during the 17th and 18th century in England, and two of those are important jurists. Sir Edward Coke said that people who were insane were idiots or lunatics, and people who had lost all memory and understanding. Now, this is important because idiots and lunatics were two important categories of people in England and made a difference in what happened to their property. And it's probably a predecessor of what many of our current laws have, that we use terms of mental defect or mental disease. But again, this is a fairly high standard. You have to have lost all memory and understanding. And then later, Sir Matthew Hale said that the best measure of insanity was whether an accused had as great an understanding as a 14-year-old ordinarily hath. So this was a little more refined, and these were before the days of Piaget. He was saying that if a person didn't have the understanding that a typical 14-year-old would have, then they could be considered insane. Possibly the most important of those early cases was in 1723, Rex v. Arnold. This was the case of Arnold was known as Mad Ned Arnold, and he was considered a known lunatic. And in this case, Arnold believed that Lord Onslow was someone who was causing him a great deal of difficulty, that Lord Onslow actually lived in his belly and was causing him great difficulty. And so he decided he was going to take care of that, and he went out and shot Lord Onslow. Fortunately, didn't kill him, but he did shoot him. And in his trial, the the judge, Justice Tracy, said that for insanity, it had to be not just some idle humor, but a man had to be totally deprived of his understanding and memory and does not know what he's doing, no more than an infant, than a brute, or a wild beast. And this came to be known as the wild beast test. And I should point out that in England, wild beasts were like deer and rabbits. They didn't have, lions and tigers and bears. So it was still a very cognitive test, not one of, being wildly out of control. And then the first half of the 19th century, things really picked up in terms of the insanity defense in England. This seemed to be a time that people were wanting to kill either the king or queen or the prime minister. So Hatfield was a man who attempted to kill King George. He was eventually found not guilty by reason of insanity, but it introduced a delusional test, which was a new concept and certainly more sophisticated than just losing all memory and understanding or being a wild beast. And it also introduced having an expert testimony in the case. And then Bellingham, in fact, assassinated the prime minister. And in his case, another new wrinkle was added, which was whether or not a defendant could distinguish good from evil or right from wrong. So it was certainly a more sophisticated kind of idea than just being a wild beast. And then Oxford attempted to shoot Queen Victoria and Prince Albert in 1840. And in that case, Oxford was also found not guilty by reason of insanity. And the rule that was introduced was that somebody wouldn't be responsible if they had a controlling disease that they couldn't resist. And that's, a very different kind of concept. It's one that's not cognitive, but really had to do with how well can this person control themselves. But the biggest of all of these cases came a few years later, and that was when Daniel M'Naughton was attempting to kill Robert Peel, the prime minister, and instead shot and killed his secretary. And he was found not guilty by reason of insanity, and there was an uproar. Not surprisingly, when there had been so many attempts on the regents and the prime ministers in those years. And so the House of Lords called together all the justices and put some questions to them about how insanity should be defined, and they came up with what is the granddaddy of all insanity standards, the M'Naughton standard. And it said that to establish defense on the grounds of insanity, it had to be proved that at the time of the act, the party was laboring under a defective reason, so they had to have a problem with their reason, that came from a disease of the mind, so there had to be some disease that caused it, such that they did not know the nature and quality of their act, or if they did know it, they did not know he was doing what was wrong. So this introduced two important components that have continued through much, but not all, of insanity law, and that is nature and quality, or did the person know what they were doing? And even if they did know what they were doing, did they know that they were doing something that was wrong? Now, this became the most widely used standard for quite some time in America. There have been many variations since then. Even in the 19th century, there was an addition that came in state court in Alabama called the irresistible impulse test. Or could a person not be able to, did they have an impulse, kind of like in the Oxford case, that they could not resist? Very difficult concept to evaluate, but it became not a standalone test, but it was sometimes added to the cognitive tests. And even in federal courts, in a Supreme Court case a few years later, they adopted the irresistible impulse test. And they also set a rule that that defendants would be considered, they would be presumed sane, just as they're presumed innocent. But if some proof was shown, if some evidence was shown that they were not sane, then the process became that proving their sanity was an element of the crime. The prosecution had to prove their sanity beyond a reasonable doubt, which became, a fairly difficult task for the prosecution. Then in the 20th century, further changes, earlier part of the 20th century, there was, experimental time in the District of Columbia where they used what was called the product test that came from the case of Durham v. United States. And the product test basically said a person was insane if their acts were the product of a mental disease or defect. Very difficult test to operate. And soon it became a problem that they considered that the mental health professionals, mostly psychiatrists at that point, were taking over the province of the judge or jury, because who knew better than they what a product of a mental disease would be. So when they spoke and they said, yes, this is the product, this action was a product of a mental disease, that carried a lot of weight, and the courts thought maybe too much. So that test, had variations, had a few attempts to improve it, but ultimately it didn't last and was replaced in the District of Columbia in 1972 by what's sometimes called the Bronner test, but actually District of Columbia was one of the later districts to adopt it, but it was the American Law Institute test, the ALI test, that came from the Model Penal Code. And it said that as a result of a mental disease or defect, the defendant lacked the substantial capacity to appreciate the criminality or wrongfulness of their conduct, or they lacked substantial capacity to conform their conduct to the requirement of the law. So there was both a cognitive and a volitional prong to this test. And in addition to that, there was qualifying language, lacked substantial capacity. So unlike the early standards I talked about with complete absence of memory and understanding, this was something that had a much more graded sort of level to it. And this was the rule that was in existence in the District of Columbia in 1981 when John Hinckley shot Ronald Reagan and a few other people. And that caused an uproar. Hinckley was found not guilty by reason of insanity. And, people watched him on TV shooting the president. And that created an uproar the way Manhattan had a century earlier. And so Congress, like the House of Lords in England, decided that they were going to do something different. So instead of the patchwork of case law in all the various federal districts around the country, Congress passed the Insanity Defense Reform Act. And this is what I was involved in most of my career, because I worked in the federal prison system and evaluated defendants in federal court. And this was the rules that came to be in 1984. And it required that there be a severe mental disease or defect. So that was one qualifier. It specified the mental disease had to be severe. But then the functional limitations that the defendant had to have were very similar to Manhattan. They had to be unable to appreciate the nature and quality of their acts, or unable to appreciate the wrongfulness of their acts. Now, one difference from monotone is the term appreciate was used rather than didn't know the nature and quality. So again, there was a bit more graded kind of rule than monotone. But they also completely eliminated the volitional prong in federal court, and many states followed after that. And they also changed the process so that instead of insanity being an element of the crime that the prosecution had to prove sanity beyond reasonable doubt, it became an affirmative defense where the burden of proof was on the defense by clear and convincing evidence. So a very big change there. And one other very big change that relates to all of us doing evaluations is that it also prohibited testimony on the ultimate issues of sanity or intent. So the federal rules of evidence changed, and it basically said that you could not, an expert in court could not testify on these ultimate issues. So, and what I mean by that is, if I went to court, I couldn't say, in my opinion, this defendant was or was not sane at the time, or did not have the intent to commit the crime at the time. Nor could I testify on what was called the penultimate issues, which is I couldn't say he lacked he lacked the ability to appreciate the nature and quality of his acts, or he lacked the ability to appreciate the wrongfulness of his acts. And this was particularly odd because the statutes also require that experts issue those opinions in their reports, but they're not allowed to testify to those in a trial. What ultimately came out of that, first, the issue of testifying about intent varies a lot by jurisdictions, but in federal court, though there's not necessarily an absolute ban, different jurisdictions have different rules in terms of whether and how experts can testify about intent, which is a kind of a complicated issue. And what experts can, and case law has argued that it was congressional intent that experts can testify fully about the defendant's diagnosis, their mental state, and their motivation at the time of the offense. So remember those three items, because those are what, at least in federal court, experts can testify to. So from that review, let me just say, some things that are not necessarily insanity. For instance, behavior that's the product of a mental illness is not necessarily insanity. That should be fairly evident. And as I said, the product test only existed for a fairly brief time in the District of Columbia, maybe in New Hampshire as well. But I've seen many reports where experts don't say they're employing a product test, but they basically argue that this person would not have committed this crime if they didn't have this mental illness, and therefore they're insane. And while that's, I guess an arguable idea, it's not the law. And so just being a product of a mental illness does not equate to insanity. Behavior that's beyond a defendant's control. And there may be some jurisdictions some state jurisdictions where that may be the case, but in federal, it is not. Behavior that results from irrational motives. So somebody may have had an irrational reason for committing the crime, but that does not equate to insanity. And behavior that's intended to result in the death or incarceration of the defendant doesn't necessarily rise to insanity. Diminished capacity is a term that's commonly used to refer to whether or not a defendant had the necessary intent that's required for the element of a crime. And there's a lot of controversy about whether or not, and there's legal cases about that I'm not going to have time to go into, about whether or not experts can testify about intent. It's certainly complicated to do that, but I just want to point out that that term is also used in federal sentencing guidelines to have a completely different meaning. Diminished capacity in the federal sentencing guidelines is an option for a downward departure in sentencing that has to do with the mental state of the defendant at the time, and it's broader than the insanity criteria, but it has a lot of exclusions. And just be aware that diminished capacity has that meaning in federal cases. So prior to doing mental state at the time, or MSO evaluations, an evaluator should know what kind of evaluation they're being asked to do, and that may not always be possible. Attorneys often are not really clear at that point whether they want an evaluation regarding intent or an evaluation regarding sanity, but at least know that you're doing an evaluation of mental state at the time of the offense as opposed to something else. And it's important to know the relevant statutes and case law in the jurisdiction you're working in so that you know what's considered insanity and what applies in terms of intent testimony. So then I want to talk a little bit about the difference between forensic and clinical assessments. And this is, I think, there's a really excellent article, fairly old now, by Stu Greenberg and Dan Schumann that distinguishes clinical from forensic evaluations. I think of it in a much simpler manner than their table did, but I think that there are assumptions and alliances and goals, and as a result of those methods that are different in forensic work than clinical work, so that, you know, in clinical work, we assume that the person is suffering in some way, that we develop a therapeutic alliance, we want to alleviate their suffering, and we accept their perspective. Now, that doesn't mean we think that they're perceiving reality correctly, but we think that they're telling us their reality. In forensic work, not necessarily. We don't necessarily think they're ill. Our alliance is really with the courts in the interest of justice. Our goal is really to aid the trier of fact. And as a result of all of that, our methods require a lot more multiple sources of data rather than the word of the defendant. So this model I'm going to be talking about for the rest of the time is one that has to do with sort of conceptualizing mental state. It's an aid really for organizing data, and it emphasizes multiple sources of data, different time periods, and a distinction between self-report and other information. And I'll say in a minute what I mean by other information. These are not necessarily novel or original ideas. There are several other authorities who certainly talk about multiple sources of data. I think the Melton book refers to different time periods, but this is a way of putting those together, I think, that may be useful for some. So here's an example, an unfortunate one. A defendant comes in and tells you what symptoms they're experiencing and displays certain behavior, and they know you're watching them. And on the basis of that, I would think most of you hopefully would not, but I have seen mental health professionals on the basis of that who then render an opinion on the ultimate issue. So one case I had a defendant who was involved in credit card identity theft, went in and told a psychiatrist that he was hearing voices and that he thought he was a variety of other people. He was actually trying to argue that he had multiple personalities, but this psychiatrist listened to his symptoms and said he was not sane at the time of his crime, just on the basis of that. And that is a very inadequate kind of conclusion, and one that would not stand up very well. In fact, in this case, it did not. So here's the model that I'm talking about, and I think you can see that there are several cells in this model, and the self-report of the defendant at the present time is one very small piece. So we're evaluating the defendant always now in the present, not at the time of the crime. And they're telling us their symptoms and they're demonstrating behavior, but they know we're observing them. And so they know, they have some control over what we see in terms of their behavior. And that's a long way from the ultimate issue. Even on my table, that's a long way from the ultimate issue. So there are two columns here, self-report and other sources of data. And other sources, I say, I don't know what else to call it. And that's why I've called it other sources of data. And the reason for that is it's not necessarily objective because, for instance, when you consider the statements of witnesses or reports of family members, they're not necessarily objective. And it's not necessarily somebody other than the defendant, because sometimes we're observing the defendant when they don't know they're being observed, or in ways that they don't understand that we're observing them, or we're giving them tests that they really can't see through. And so, so it's not necessarily just data from other people. So to have a more complete picture, even at the present time, we do a variety of things. We do psychological tests. We do, if necessary and appropriate, neuropsychological tests. We usually do mental status exams. Mental status exams, defendants may have control over telling us their symptoms, but most defendants don't really know and wouldn't be able as easily to display, for instance, a flat affect or loose associations. Behavioral observations, especially when they're unobtrusive. Now, this was the great benefit of working in an inpatient institution, because I could often watch people at times when they weren't sitting in my office. I had one defendant who was supposedly suffering from a very severe brain injury, who was regularly sitting out in the yard with other defendants or other inmates playing chess. But when he came in my office, he couldn't pronounce, he couldn't name simple items, and there was clearly something else going on there. And sometimes, again, especially in inpatient units, medical or neurological tests. So one young man I evaluated from an African-American male from down in the South, when I spoke with his family, I talked to his mother, who had not seen him for a while, and then she went and met with him a short time before the crime, which was a carjacking. And she told me that his skin was much darker than in the past. And that seemed odd, and it certainly seemed like something a mother would notice. And so I discussed that with one of our psychiatrists, and he said, well, it's possible we should at least consider that he may have been suffering from porphyria, which can have neurological effects and can change skin tone. And so he did a 24-hour urine test to see, and it turned out that this defendant did not have porphyria, but at least we had that opportunity to determine that. Psychological tests, probably of all of these, are the ones that we would most frequently be doing, at least psychologists among us would most frequently be doing, and would find particularly useful. Now, in one case, I was evaluating a defendant who was charged with very complex identity theft crimes, and yet he came in and looked like a disorganized schizophrenic. I mean, he he really did demonstrate strange affect and loose associations and very convincing presentation. And when I tested him, I gave him an MMPI and I gave him a SIRS, and he came out as, with strong indications of malingering from those tests. And I was very surprised by that, actually, because I was impressed by the mental status that he presented. And I'll talk a little bit more about him in a minute, but in the best case scenario, at the present time, what we can do is we can give an opinion about a defendant's present mental status and possible diagnoses. And I say possible because, in the diagnostic criteria, there are always duration and time elements that are involved. And so we may not be able to give a definitive diagnosis. So what we need is some historical information. And so that brings us to the next category, which is history. Now, I always would take a detailed history from defendants and discuss their childhood, their education, their employment, their relationships, substance abuse, criminal record, past psychiatric treatment. And it was very important to do that. And I know that, in some settings there may be a division of labor, and that kind of history may be taken by a social worker and then shared with a psychologist or psychiatrist who's conducting the evaluation. But I found it very useful to do that. Not only does it help, establish my rapport with the defendant, but also sometimes it brings up issues that are really contradictory to other information and lead you to check on things more. It also gives you an idea of their patterns of perception, how they view things that happen in their life, and can be very useful in the final formulation. So I think taking a history is a very useful thing. Taking a history yourself is a very useful thing to do. Equally, and maybe even more important though, is having other sources of data for history. So having past psychiatric records, especially if they've been in psychiatric hospital before, past records can tell us something about patterns of behavior when people are mentally ill and what their past symptoms have been, what they've been like when they've had an acute disorder. Knowing their past arrest record can be important. The young man I was talking about that we did the porphyria test on, he was charged with a carjacking, a very serious violent crime actually, in the South. I'm not going to mention the state exactly, but in his case, when I looked at his NCIC, his arrest record, he had a significant past incarceration in Illinois. But when I took his history, he said, I asked him about past incarcerations. He said he never had been, and I challenged him with that information, and he looked puzzled and continued to deny. And I contacted the FBI agent in the case because I was very confused. This very unusual name, and the entry in the NCIC was that name with that birth date. And when I talked with the FBI agent in the case, he said, "Yeah, we were puzzled by that too, and we checked, and actually somebody had stolen his driver's license at one point and used his name and got arrested in Illinois and used his name when they went to prison." So interestingly, that defendant actually, his arrest record was not an accurate reflection, but most cases it will be, and certainly the discrepancies need to be clarified. Employment records may or may not be useful because many defendants are not employed. But I was evaluating a defendant charged with murder in Arkansas, and he had been working at the time, and I was able to get his work evaluations And they certainly helped in terms of having a better picture of what his day-to-day functioning was like. School records as well may not always be applicable. Certainly if there's question of an intellectual disability or of a developmental disorder, school records would be important to have. But if you're evaluating a 45-year-old defendant who dropped out of school in 10th grade, those records may not be, otherwise all that useful. However, I was evaluating once a university student at University of Texas who was charged with a bank robbery. And I happened to be able to get his school records from the semester in which he committed the bank robbery. And he was doing well. He was doing well in his classes, at least as well as he did in any other semester. There was really no difference between his work in previous semesters. Military records can be important, especially if we're talking about a possible diagnosis of PTSD. One defendant I had was actually charged with threatening the president because he was not being given disability for PTSD. And he was in a hospital at the time. He was in a VA hospital at the time that he made the threats. And so I got his military records and discovered he was a Vietnam era veteran, but he had never been in Vietnam. And in fact, when I asked him about that, his explanation was that people like him, he had served his time in Alaska, people like him were the ones who made it possible for other people to go to Vietnam and get their disability. So he thought he was entitled to it as well. But military records can be especially useful, particularly for patterns of, or for diagnoses like PTSD. I have to say, if there's one source of information that I have found possibly more useful than any other, it's probation officer accounts. And that's because, many defendants, when they're being charged, it's not their first offense, and they may have been on supervision at the time they committed the offense. And I had that happen a number of times. In one case, locally, someone robbed a bank here in Springfield, Missouri, and I talked to his state probation officer. And one of the things I found is right after he robbed the bank, he was placed in a local jail facility, and the probation officer went and had a urinalysis done. And when I evaluated him, he was presenting a lot of convincing sounding visual hallucinations from the time of the crime. And then when I talked to the probation officer, she let me know that she did a UA at the time he was incarcerated in the jail, and he was testing positive for meth, which I would not have otherwise known. Even the federal prosecutor and defense attorney hadn't known that at that point in time, but it was an important piece of information. In another instance, the young man who was claiming that he had multiple personality disorder and had convinced the psychiatrist that he was not sane at the time just based on his reported symptoms. He gave me a written, detailed history of his life, and in the history he had several blank periods that he said, he had these spells, these times when he just couldn't remember what happened, and very dramatic and very interesting blank periods. And then I checked with his federal probation officer because he was repeating, he was incarcerated at the time he committed these crimes, these identity thefts. He'd get on the phone and he would call credit reporting agencies and pretend to be merchants, and you'd have to do it multiple times, but every once in a while he'd get somebody's credit card number and he would have a new credit card mailed to an address that he wanted. And interestingly, he had already had one conviction while he was incarcerated for that crime, and the probation officer had done a pre-sentence report, and he provided a written history to the probation officer. And when I contacted the probation officer, they said, "Oh, he gave us a written history. Would you like it?" And they sent it to me, and sure enough, it was missing all of the blank spells that he had reported in his history they had given to me. And finally, friends and family are so crucial. I mean, getting reports from family members and friends who have observed and can give you information about defendants. The young man I talked about who tested, had tests suggesting malingering, but who had a mental status when I evaluated him that was very impressive in terms of his loose associations and his flat affect. And I was very puzzled by that discrepancy. And I talked with his mom, and I asked her about his mental disorder, and she said, well, he doesn't have any mental illness. And I said, oh, and she told me then that, well, his brother's schizophrenic, and he did take care of his brother for a couple of years. He lived with and took care of his brother, who does have schizophrenia. So then, it made sense that this person whose day job was an identity theft was able to take on the identity of his brother, or at least symptoms similar to those of his brother. Okay, so even if we have all of that information, what we then have is historical symptoms and pattern of diagnosis and patterns of behavior that can be very important in terms of, is this offense behavior similar to behavior during previous times of mental illness? But then we need what is also critically important and information, which is the time of the offense. So we need to know from the defendant their explanation of what they were thinking, what they were feeling, and what they did prior to and during and following the offense. And I would always get very detailed accounts from the defendant about this. And I usually would start by asking them to tell me what happened and to begin at the point they thought they would need to begin in order for me to understand what happened. And that was, I found, very useful because it really would help often with their motivation, explaining how they got to the point of this particular offense. One individual who was charged with taking hostages in a federal building, he began his account years earlier with his wife's employment because he believed she had been unfairly fired and that there had been some federal involvement. And over time, he became delusional in regard to this and ultimately committed this crime. But after we have the defendant's explanation, then again, critically, we need detailed information from other sources at the time of the offense. So we need arrest reports, investigative reports, witness statements, and I'll go through the benefit of a few of these things. For instance, in investigative reports, the young man whose school records I talked about earlier, he was a bank robber. His defense was characterizing the bank robbery as very like crazy behavior. But in fact, when you read the investigative reports, it was a really good bank robbery. And he took the clothes he was wearing and he ditched them in dumpsters in different parts of the city. And then and he almost got away, except that there was a tracking device in the bait money, and they just happened, a law enforcement person just happened to pick up his trail as he was leaving town. But those records were very useful, and arrest records are very useful. It's rare to have video or audio tapes at the time of a crime. However, if it's a sting, I've had cases of individuals who were involved with a confidential informant in a sting operation. In one case of a lawyer who was trying to have his ex-wife murdered, and it turned out that the person he was hiring was actually an FBI agent who was recording these encounters, and I was able to see his real-time behavior with this person, and that became very, very important information, but not that often available. When there's physical evidence, it's just critical to have that. I once evaluated a person who robbed a post office in a small town in Florida, and a psychologist for the defense was arguing that he didn't have the intent to rob the post office. Again, one of those things very hard to explain. But as he testified, he said, "Your Honor, he robbed a small rural post office. If he wanted money, he would have robbed a big post office in town that had a lot of money, but he robbed this small rural post office." What he paid no attention to in the actual physical evidence of the crime was that he robbed a post office that only had one person working there, which made it much easier to rob. And what he stole was actually a stack of blank postal money orders and a money order imprinter, so he could make as large a money order as he could have from a large post office. Confessions. Oh, I want to say one more thing about physical evidence. The young man I've referred to before, who did the carjacking in a state in the South, he was actually in the process. It was very, very a dramatic crime with multiple carjackings, shootings. Ultimately, he was shot. He was taken to the hospital. He was evaluated in the hospital by a psychiatrist who diagnosed him as having a drug-induced psychosis. And that was particularly important. He saw that he was psychotic, and he attributed it to drugs because he said he tested positive for benzodiazepines and opiates, which I thought not typically what you would expect, but that's what he found. But I couldn't get the records from the hospital. I couldn't get the lab reports, and I tried and tried, finally got hold of the hospital pathologist, and he told me that he was able to find it through another system they had. And what we discovered was that there were two sets of lab reports. When he was first admitted after being shot, and he didn't have drugs in his system then, and then while they were treating him in the hospital, they gave him Ativan and morphine, and then they released him to the jail where he really wasn't well enough to be. So they returned him to the hospital. He was readmitted and of course had new labs, and those labs showed benzodiazepines and opiates. But of course they gave them to him a few hours earlier. And on the basis of that, the psychiatrist had argued that he was at the time psychotic because of drug-induced. Okay. One more thing, because we're running out of time here. The last thing I'll say is on confessions. Why that's important is when arrests are made close to the time of the crime, most confessions are done on video, if not on audio, at least, if not videotape. And if you can get those videotapes, which I've usually done, and can see the defendant, both what he's saying about the crime and how he appears, how he's talking, how his behavior and mood appears at the time, they're really valuable. And when you have all of those things, then you can put together from both the current mental status, from the historical symptoms and pattern, and from all of that information from both sources about the rest, and you can make a fairly robust, I think, offer a fairly robust opinion about mental state, motivation, and diagnosis at the time of the crime. And it's one more leap from there to the ultimate issue. In federal court, you're not allowed to take that leap except in your report, but not on the stand. And there are many mental health professionals who argue we shouldn't take that leap anyhow, that we should stop at the point of mental state, motivation, and diagnosis and let the trier of fact make that other determination. In any case, I think having information from these sources, and in no case are you going to have all of the information from all of the sources, but the more you can have from more, hopefully from at least all of these 6 domains, the much stronger opinion can you offer about a defendant's mental state at the time. And I think, speaking of time, I'm out of it. So I'll stop there, Julie.
Thank you so much, Dr. Mrad. Really appreciate it. That was a great talk and also a really great plug. Let's see, we've got on January 5th, Chris Slobogan's going to be presenting The Ultimate Issue. So in terms of question,
Great.
Yeah. Say that again?
What day is Chris presenting that?
That will be January 5th, so right at the new year.
Okay.
All right. Our first question is that this individual says, I did not understand the point you were making regarding the armed robbery defendant who had done well in college that same semester. What inference do you draw from that bit of data? Why can't a person qualify as insane and also simultaneously be a good student?
Oh, that's a very good question. And I didn't really have time to elaborate more, but in fact, what the defense was arguing was that he was going through an acute manic episode at the time of the crime. And there was no evidence from his records of that. Certainly, there are a number of ways somebody could still do well in school and possibly qualify for insanity, especially if there's a delusional disorder, but that wasn't the case in this particular instance. And sorry, I didn't have a better explanation of that.
The next question is, what's the developmental disability resulting in a successful insanity defense? How often have you seen this occur?
I don't know that I've been involved in cases where that has occurred. And I have to say, especially if it's well documented, one of the reasons I may not have seen many of those is oftentimes when there's a well documented history of some kind of fairly severe limitations, prosecutors will consider that earlier than it ever gets to me, so that there's already some resolution decided upon between the prosecution and the defense without ever going for an evaluation.
The next question is, if records support that there were drugs in their system, but they have a long-standing history of mental illness, how does this impact your opinion on the case? Should a defendant be opined as not sane if there were drugs active in their system at the time of the offense?
Well, I don't know that there's a yes or no answer to that. It's certainly a difficult question. There's also a difficult question about whether or not someone who has a long pattern of drug abuse may have what is sometimes called settled insanity, where they're the effects of the drug use is not present intoxication, but some effect to their neurological functioning over time. So I don't know that that's something that can be answered yes or no in terms of, I think it's kind of separating an intoxication effect, which, and I think probably all jurisdictions would not qualify for insanity, from an effect, a longstanding, more permanent effect of drug use, and that would be very case specific, I think.
The next question is, how do you attempt to correct for defendants who are referred years after the crime and are now competent and attempting to rationally fill in the blanks per se, or make logical sense of their behavior? And and possibly confabulate.
Wow. And possibly what, Julie?
Confabulate.
I didn't hear the last part of the question.
It's
Confabulate.
Yeah.
Yeah. Again, the more information you can obtain from other sources, the better, because I've had cases. Certainly, the more common case is somebody who's been charged with a crime in the past year. But I've certainly had cases where I've been asked to give an opinion about somebody's mental state at the time of a crime that occurred 5 years earlier. And that can be very, very difficult to do. Not only is there the complication of to what extent the defendant may be intentionally presenting information that's inaccurate, but as the questioner is suggesting, they may also be confabulating. They may be filling in blanks for things that they don't really remember. And in some cases, I think I've seen defendants filling in, giving explanations that help them understand their behavior as being more rational than it actually was. And so they come up with explanations that kind of put a rational spin on their behavior that may not have actually been there. But the longer the time has passed, the more difficult that task is going to be. And unfortunately, what may also be more difficult is getting information, all the other information sources that I'm talking about. The farther you get from the crime, the more difficult it's going to be to get all of this other information about their history, and also hopefully it's not still a problem getting information from about the time of the crime, but there may be.
All right, I think this is our final question since we are 10 after. And this last question is, while obtaining information from multiple sources, I also obtained a detailed narrative by the defendant for his perceptions at the time of the event. Verbatim quotes and other details from that interview were ruled inadmissible, as was my opinion about the defendant's credibility during the interview. Would you please comment on admissibility of a defendant's narrative or credibility?
I'm really puzzled that the defendant's statements would not be considered admissible. Now, I wonder if there's more information involved in that. What we typically did at the medical center was we were often asked to evaluate competency and sanity at the same time, because individuals were being sent from around the country, and they didn't want to send them more than once. And so we would evaluate defendants And sometimes if we were asked to evaluate both their competency to stand trial and their sanity, then in keeping with the specialty guidelines, we would not include any of their statements about the offense in our report on competency. But we did do a separate report on sanity, and we would include their statements in that report. And I have not encountered a court that would say that the statements the defendant gave to me about the offense would not be admissible. I'm not sure maybe there's a legal reason for that I'm not aware of, but I don't know what that would be unless, for instance, it was done at a time prior to competency being, those statements were given at a time prior to competency being determined. But even then, I'd be surprised if the defendant, I assume the defendant was given fair warning and an explanation of how the information would be used, because otherwise I don't know why it would not be admissible. Maybe some attorney can answer that question. Sorry.
Okay. Dr. Mrad, thank you so much. We really, really appreciate your time today. This was fantastic. Lots of other questions that maybe we can pass on to you. But in terms of today, we can go ahead and end. For those of you that are still on, we'll be on for about 5 more minutes to allow you to get that CE link. But other than that, thank you all so much.
Thank you, Julie.
Have a good day.
Okay, folks, I'm going to set a timer for 5 minutes for the CE link. And then when that timer is up, I'm going to end the webinar. We thank you once again for tuning in today. Have a wonderful rest of your day. Okay, I just got the questions. The link can be accessed in the chat function. If you scroll down to the bottom of your screen, there should be a chat button. If you click on that, the link should be posted there.